And greetings and welcome to the Law of Evidence relating to the family from American Jurisprudence. I'd like to welcome everyone here. And if you haven't already, please hit the like because I'm not sure the notifications actually went out. And that'll help get more people in here to interact with the reading here of the Law of Evidence from American Jurisprudence. So today we're going over Part 3, the relationship between spouses, starting with Section 223, property ownership. Before we go any further, just remind everyone, this is strictly to be used for the entertainment and educational purposes of this YouTube broadcast, only not to be used, misconstrued, or misused for anything personal, private, legal, lawful, professional, financial, tax, or otherwise. Please don't do this at home. All right, let's continue. Property acquired by either spouse subsequent to the marriage and prior to dissolution is presumed to be marital property regardless of how title is held. In many states, the community property system prevails, which presumes that property acquired after marriage is community property of husband and wife. The party asserting that the property is separate has the burden of overcoming this presumption. The presumption that property acquired by either spouse during the marriage is marital property can be overcome by showing that the property was acquired by gift, devise, descent, or bequest. Wow, that's footnote 3. And this comes from this case here, Wilson versus Wilson and Pemberton versus Pemberton. All right, let's continue. The common law presumed that the husband was the owner of all property possessed during marriage, and the vestiges of this presumption still prevail in some jurisdictions, but this presumption has largely been abandoned and its validity is constitutionally suspect. So, community property in the AmJur 15A. It will be presumed, in the absence of evidence to the contrary, that household goods, where husband and wife are living together, belong to the husband. Husband, as head of family, constructively possessed drugs found in marital home. Yikes. Proceeds or derivatives of real property held by entirety as themselves held by entirety. And we have here from Hawaii, married women are equal with husband as to ownership of the marital estate. And here we have Moulton versus Moulton in Maine. By force of married woman's acts, passed in all jurisdictions, the common law doctrine that marriage deprives a woman of separate property has been abrogated. Interesting. That was Maine. Here we have striking down Louisiana law, permitting husband to dispose of jointly owned marital property. So I wonder how that one went as far as what was the conditions for that happening in the first place. All right, let's see here. Oh, here is the Petty versus Montgomery. Statute limiting freedom of married women to alienate or mortgage her lands without husband's assent violates equal protection clause of state constitution. Wow. And as to the property rights of spouses generally, 41 AmJur, husband and wife. So we have a whole volume there dedicated to that, which takes on to section 224, gifts and advancements. As we saw, one of the exceptions here to community property is, we had a list over here, by gift, devise, descent, or bequest. So now we're on to the gifts and advancements. Let's jump over here to the chat and make sure we're up and current. Greetings to you, Bill Thomas. And audit them. Indeed, hit the thumbs up. A conveyance of property from one spouse to another is presumed to be a gift. Oh, interesting there. Expenditures made by a spouse on property held by the entirety are presumed gifts. Each spouse owning one half. Wow, unless rebutted by clear and convincing evidence, not just beyond reasonable doubt or preponderance, but clear and convincing evidence that such payments were made with the intention not to be considered gifts. Even where one spouse supplies all the consideration for property held as tenants by the entireties, there is a presumption of a gift to the marriage. Transfer of title from one spouse to the other creates a presumption of gift. That presumption can be rebutted only by clear and convincing evidence. And if a spouse transfers title of her separate property to joint names, a gift will be presumed. There is also a presumption where property is held by the entireties that either the spouse may act for both without specific authority, as long as the benefit inures to both. Interesting here. So we're looking at transfer of title of property here and various conditions here. We have some instances here in the footnotes here, Graham versus Graham, Charlton versus Charlton, and I'm not going to say that one. So we're on to section 225, agency and duty to provide. The marital relation alone raises no presumption of agency between husband and wife. The burden of proof is on the one asserting agency. If there is an express statutory provision, the husband is presumed to be acting as the wife's agent, where she permits him custody, control, and management of her separate estate. But this presumption can be overcome by evidence. At common law, a husband was under a duty to provide his wife with the necessities of life, and she was thus presumed to have authority to bind him for necessaries. Should the husband neglect his duty, he may be liable to third parties for necessaries furnished by them to the wife. There is authority that the doctrine is still viable. But as the partners in the marital relationship become more interdependent than dependent, this common law rule has become more egalitarian. Wow. So this is an interesting one here, all for footnote 18. Webb versus Hillsborough County Hospital Authority in Florida. Under statute, both husband and wife are jointly and severally liable for expenses of the family. Wife has joint and mutual obligation to pay for necessities. So wonder what year this is. Nonetheless, we're looking at a 1998 edition of this. So there's going to be much more current cases, which is why this is just for the entertainment and educational purpose of this broadcast and not to be used for anything legal, lawful, personal, professional, and don't do it at home and all that. So as we see here at common law, and of course there's vestiges of this, but most of it's, as I was saying before, is suspect to constitutional rebuttal, at least what they suspect here. But it says at common law, the husband was under a duty to provide his wife with the necessaries of life, and she was thus presumed to have authority to bind him for necessaries. Should the husband neglect his duty, under bond, right, he may be liable to third parties for necessaries furnished by them to the wife. Wow, that's a very odd arrangement there. There is authority that the doctrine is still viable. And that's 17. Steingesser, New York, Richland Memorial Hospital versus Burton. Here's her annotation. Necessity. An action against husband for necessaries furnished wife of proving husband's failure to provide necessities. Proving. Wow. Interesting there. All right, so this takes us on. I think we're done with this section here. Yes, indeed. We're on to section, or actually, this is going to be subsection B, children, with part 1 of this, presumption of legitimacy. Starting with section 226, generally. And let's jump over to the chat, make sure we're up to date here. Greetings, common sense. We should have lots of that here. All right. The presumption of legitimacy is considered one of the strongest in the law. As such, with few exceptions, it nearly always takes more than a mere preponderance of evidence to overcome it. Courts express this burden in a variety of ways: substantial, clear and convincing, strong and conclusive. Traditionally, the presumption of legitimacy could be rebutted only by a proof that the husband was incapable of procreation or had no access to his wife during the relevant period. And, under common law, neither husband nor wife could be a witness to prove access or non-access. Wow. So this, I guess there's some third party has to be able to corroborate that, it seems, by proof that a husband was incapable or had no access. There it is. All right. And let's see, footnote 26 on that. No further detail. We're on to the scope of presumption now. And the presumption, see here. The presumption of legitimacy applies to a child conceived during a marriage, but born after annulment, divorce, or separation. To rebut the presumption, the presumed father must assert and prove the same grounds as if the couple had still been married when the child was born. Wow. Born after annulment, divorce, or separation. So must prove the couple had still been married when the child was born. Wow. Moreover, the presumption applies to children conceived before but born during marriage. Oh. The presumption is particularly strong where the husband knew that his wife was pregnant before their marriage. The presumption of legitimacy is upheld, sometimes even in the face of conclusive evidence proving that the man married by the pregnant woman was not, in fact, the biological father. Wow. So it seems that being born at the time of being married at the time of the birth, conclusive evidence proving, that's footnote 31, and nothing more than Blitch versus Blitch in Florida. Let's see here, post-birth. Well, let's get back here. All right. Moreover, the presumption applies to children conceived before but born during marriage. Okay. The presumption of legitimacy is upheld sometimes even in the face of conclusive evidence proving that the man married by the pregnant woman was not, in fact, the biological father. And post-birth marriage is some evidence that the husband is the child's father, but, without more, is insufficient to prove paternity, even if the husband seeks status as the child's father. Presumption of legitimacy or of paternity of child conceived or born before marriage, American Law Review. And that's it. We have no other further details except for this discussion on the scope of presumption of legitimacy and paternity of children. That's under 10 American AmJur. Bastards. So this is where legitimacy comes in, the scope of the presumption. So we're looking at the range of the various presumptions that apply to legitimacy. All right, let's proceed here on to section 228, standing to rebut the presumption. Let's jump over here to the chat once again. Bill Thomas says, if you have a funny name, you seem more likely to get a legal precedent. Yeah, Blitch versus Blitch. Interesting. I think that, on purpose, the appellate courts, when they see something like that, they're like, yeah, we'll take this case. I like that name. So, some states, by statute or court rules, limit those who may challenge a child's legitimacy, affording standing at most only to members of the immediate family, that is, wife, child, husband, and their descendants. When the child's mother was married to another man at the time of conception or birth, and the husband considers himself to be the father, the conflict between the purported unwed father's paternal rights and the presumption of legitimacy arises. Natural fathers, who were not the husbands of the child's mother, have generally been denied standing to bring legitimacy actions alleging their own paternity, although occasionally natural fathers in such circumstances have been granted standing. A statute denying standing to the purported biological father by means of a conclusive presumption does not violate the Due Process Clause of the 14th Amendment. Key. Non-descendant relatives of the deceased husband are also denied standing to the question the presumed legitimacy of children who had been conceived by or born to the wives of deceased husbands. 39. Oklahoma. Okay, so let's see here. Who may dispute presumption of legitimacy of child conceived or born during wedlock? Is an American Law Review. All right, so you can see here, these are some contentious cases here. Takes us section 229, grounds, lack of access. And jumping over to the chat, give a quick refresh here. All right, we're on track. The common law rule that husband and wife are not competent to testify as to lack of intercourse as a way of proving that a child was illegitimate has been rejected in many jurisdictions. In some states, however, the rule remains in force. In such cases, corroboration of inaccessibility is sometimes required. This is funny. Let's see here, footnotes here. Where'd it go here? 40. So this is just a whole slew of citations. Rules regarding competency is to testify as to non-access, presumption of legitimacy. Wife, here we go. This is what we're looking for here. Wife not permitted to testify to the ultimate fact of illegitimacy. But the trial court did properly permit her and the first husband to testify as to the first husband's non-access at time of conception, thus showing the impossibility of the first husband's paternity. So, here we go. Sometimes required. Let's see, 42. No, we just got the case here. All right, now we're on to section 230. Husband's sterility. Evidence of a husband's sterility, without more, does not generally overcome the presumption of legitimacy. Wow. However, evidence that the husband has undergone a vasectomy prior to conception, coupled with the post-pregnancy evidence of sterility, has often been considered sufficient to overcome the presumption of legitimacy. But where the couple was cohabiting, and having sex at the time the wife became pregnant, and there was no evidence other than the pregnancy suggesting that the wife had intercourse with anyone other than her husband, courts have seized on comparatively minor weaknesses in the husband's evidence to conclude that evidence of a vasectomy was insufficient to overcome the presumption. Wow. Talk about not getting your money's worth there. The fact that the husband was diagnosed as having a low sperm count did not overcome the presumption of legitimacy. Yep, only takes one. Proof of husband's impotency or sterility as rebutting presumption of legitimacy. The American Law Review. That's definitely not a stimulating read. Here we go. Tosh versus Tosh. The doctor who performed the vasectomy testified that there was a 1 in 50 chance, where does he come up with these numbers, that a man might regain fertility after a vasectomy. The doctor who conducted a pre-trial fertility test testified only that it was almost certain that the husband could not have fathered the child. Almost certain. I love that one there, is that's tests normally taken in the second and third month following a vasectomy were not taken. Uh-oh. The test to determine whether vasectomy had been successful was not performed until approximately 10 years after surgery and 5 years after child's birth, and his own experts stated that vasectomies sometimes fail and that their effect may be reversible. Jeez. All right, well, we got past that. We're on to section 231, scientific evidence. All right, and over to the chat. Okay, I don't blame you guys for not piping up on that one. Scientific tests are generally admissible to rebut the presumption of legitimacy. Indeed, the result of a properly conducted test that satisfies legal standards of probability is sufficient to permit a fact finder to conclude that the presumption has been overcome. But scientific evidence is not admissible where there is a conclusive presumption of legitimacy. So that conclusive, clear and convincing evidence of legitimacy, right? It's not going to be admissible with that scientific mumbo-jumbo. Nor is scientific evidence admissible if a husband is estopped by law from denying paternity. Oh, footnote 48. Smith versus Smith, where putative father held himself out to be father of child by marrying mother and assuming responsibility for care of child, paternity was established, and evidence of blood tests was inadmissible to disprove paternity for any purpose. Wow. That's an interesting one right there. And that's in this case, I guess, where, let's see, so putative, I think that was related more to reputation, reputation, right? So he's known for that. I think we went over that word before, so I won't belabor us to go through it again. So we'd say where the putative father, the known father held himself out to be father of child by marrying mother and assuming responsibility for care of child, paternity was established. And evidence of blood tests was inadmissible to disprove paternity for any purpose. Wow. So it's interesting how that comes into play, things like that. This is footnote 48. When a married woman alleges that a man other than her husband fathered her child, scientific evidence may suffice to overcome the presumption of legitimacy when the husband does not contest the issue. Scientific evidence may also be admissible where a wife seeks to overcome the presumption of legitimacy in order to deprive her husband of his rights as father to a child he has loved, supported, and helped to raise. Wow. That's cold. Especially the way they wrote it there. And that's Atkinson versus Atkinson, Michigan. Trial court properly admitted the results of husband's test. A husband denying paternity is permitted to present the best evidence to overcome the presumption of legitimacy. The court reasoned, a wife similarly should be allowed as mother to present the best evidence challenging the father's claim of paternity. Wow, some pretty heavy stuff here. Footnote 50. Okay. But even the certainty of scientific evidence will sometimes give way to pragmatic and policy considerations surrounding the child's overall welfare, which takes the marriage of Ross. Grounds prior to deciding whether to order blood tests to determine whether a presumed parent is the biological parent, the district court must consider the best interests of the child, including its physical, mental, and emotional needs. All right, well, that takes us to the end of, I think footnote 46 is that case we read there. Holding that presumption that a man is father of a child, where he and the mother are married to each other when the child is born, can be overcome by clear and convincing evidence, such as the result of scientific tests and incidents of sexual intercourse between the mother and the putative father near the time of conception. Oh boy. So I guess you got other people testifying that she was with him doing that thing. All right. I digress. Let's move on. We're on to part 2, other presumptions involving children. On to section 232, possibility of having children. And let's jump over here to the chat and see where we are. And Captain Jack, never pay a government to marry. I won't say it's advice, but it sounds like it would be a good one. Yeah, Jerry Springer show in the courts is what we're reading today. You got that right. Yeah, nothing here about that. This is about between two parties here, and this is where the courts are supposed to be dealing with. That stuff is, getting into a whole nother ball of wax. So, American courts have frequently, with regard to both men and women under various circumstances involving property rights, applied the presumption that the possibility of issue is never extinct as long as a person lives. With respect to women, most of the cases recognizing the presumption have supported the view that the presumption is conclusive or absolute and is applicable even though the underlying facts seemingly support a contrary conclusion. However, in an increasing number of cases, it has been held that the presumption will not be followed in the face of a positive evidence that a woman is incapable of having children. In other cases have, without discussion, simply disregarded the presumption of the possibility of issue. In one such case, it has been said that the principle that there is an irrefutable presumption or rule of substantive law just a moment here. All right. In one such case, it has been said that the principle that there is an irrefutable presumption or rule of substantive law that a woman is capable of bearing children throughout her life, regardless of the actual truth of the matter, is not so firmly established in the law as to require its indiscriminate application in all cases. But whether it is applicable must depend upon the nature of the particular case. Indeed. Advanced age or a surgical operation resulting in the cessation of the power to procreate has been frequently considered as a primary factor in determining that the evidence was sufficient to rebut such presumption. There is authority to the effect that while the presumption of the possibility of issue, these words, possibility of issue, may be rebuttable as far as women are concerned, it is not rebuttable as to a man. Currently, however, the rebuttability of the presumption of the possibility of issue as to a man has been gaining recognition. Oh, Lord. Evidence of a physical condition showing the lack of power to procreate has been held sufficient to rebut the presumption. And here are lots of footnotes. I can only imagine how this has changed to today. Oh boy. Remember, this is a 1998 supplement, so in the absence of any showing to the contrary, it was presumed that a female was capable of bearing children. Modern status of presumption against possibility of issue being extinct. You can read in the American Law Review. And here we have, under the theory that once evidence is introduced to the contrary of the presumption, the bubble bursts and the presumption vanishes. I think you came across that word in, what was that in? Bouvier's? Or Black's, the bubble burst in presumptions. I think the bubble bursts when either the inference or a basic fact has been disproven. The presumption vanishes if evidence is introduced showing that it is contrary to the presumption that a woman is still capable of bearing children. The presumption vanishes. Talk about bursting bubbles, huh? The restatement of property, section 274, states 4 instances in which the presumption of the possibility of issue is not conclusive. So here they are. Check 1. To enable the distribution of an estate or fund. 2. To terminate a trust. 3. To permit specific performance of a contract for the sale of land. And 4. In determining the amount of estate tax. As to application of the rule against perpetuities, the restatement of property, section 377, has adopted the traditional view, treating the presumption as conclusive. Similar provisions are not contained in Restatement 2D property, although Restatement 2D property donative transfers, section 1.4, Common H, adopts a wait-see approach under which the failure of an interest that may occur as a result of the birth of another child will not occur if another child is not born. So there's your restatements of property. In case there's any confusion, is how they're going to want to rule on these things. Let's see what else we got here. Oh, here we go. Some more here for Hamilton Bank. Okay, they have here, it was held that a finding that the possibility of a life beneficiary having issue was so remote as to be negligible within the meaning of a Treasury regulation respecting the probability that a charitable transfer will not become effective was supported by evidence that a life beneficiary was 54 years old, had been single since his divorce about 30 years previously, had never had children, and was unknown to have had any association of any kind with the opposite sex since his divorce, and was described as being dirty, offensive, and an odd character, with a history of ill health and lack of cooperation with medical advisors. Jeez. Man was impotent and sterile, in footnote 60. Let's see which one that was. Evidence of physical condition showing he had a lack of power to procreate has been held sufficient to rebut the presumption. Okay. And that was, what he had, medical, well, it just says man was impotent and sterile. Jeez. And so any further details than that, and it takes us section 233, custody, primary caretaker preferences. Refresh in the chat here and see what we got. Not sure if this is refreshing, if there are people still here. This can get kind of frightening for some, but it's good to know how these things actually pan out in our day-to-day marital familiar transactions. Let's continue. In awarding child custody, some states recognize that a presumption that the best interest of the child, particularly one of tender years, would be served by awarding custody to the parent that was the primary caretaker. Under the primary caretaker presumption, the court must determine whether the primary caretaker is a fit parent. That is, whether he or she achieves a minimum objective standard of behavior which qualifies him or her as a fit parent. Footnote 62. West Virginia, Stacy versus Stacy. The primary caretaker analysis replaces the common law presumption that, at least as to children of tender years, usually below the age of 5, a preference should be afforded to the mother. Primary caretaker analysis replaces the common law presumption. And just a bunch of divorce cases looks like there. And we're on to section 234, the capacity to commit torts. All right, Bill Thomas still there. Yeah, it's a not much to comment on this stuff here. I think it all speaks volumes. Some states may recognize a rebuttable presumption that a child between specified ages was incapable of committing a tort. A few states recognize that a rebuttable presumption that children between certain ages, usually between 7 and 14, are not capable of acting negligently. Well, so 6 they are? Most states say a child under a specified age is unable to commit negligence as a matter of law do not recognize any true presumptions as to whether a child above these specified ages is liable for a negligent tort. The prevailing view is that children above that age may be capable of negligence and that whether a particular child was negligent is a question of fact. Wow. Occasionally, a child's non-compliance with the law raises a rebuttable presumption of negligence so that the child has a burden of showing that he exercised a standard of care reasonably expected of a child of like age, experience, education, and intelligence. Oh, well, that's a lot of criteria there. How many adults, have reasonable standard of care? Child between the ages of 7 and 10 years presumed incapable of committing a tortious act. Acknowledging the presumption for children between the ages of 7 and 14 years, where a 9-year-old plaintiff struck by a car was held accountable for his contributory negligence while crossing the street on a red light. Oh, Lord. Acknowledging the presumption for children. Okay, so that's the presumption of negligence. Okay. So as to a rule governing a standard of care, particular presumptions regarding the capacity of a young child to commit a tort are discussed in 57 negligence. So 57 AmJur, negligence is where we'll find that, but we're not going to be reading that one tonight. So let's continue on to section 235, contributory negligence. A child below some certain age is conclusively presumed incapable of contributory negligence. Few states recognize a rebuttable presumption of incapacity for children between certain ages. Here's our annotation, modern trends as to contributory negligence of children. Contributory negligence of child injured while climbing over or through railroad train blocking crossing. Oh my gosh. Oh, over or through the railroad train. It was blocking the crossing, so this child's crawling around it. Wow. Yeah, you get injured doing that for sure. All right, well, that takes us to the end of this section here between the relations to the family, to children, marriage, and the law of evidence from American jurisprudence. Let's get back over to the chat. Standard of care for children seems to have changed a great deal over the last 50 years. Indeed, as we've strayed away from the common law, that, the first, there should be certain presumptions for traditional, ways of rearing children, and that's been lost with these analysis and more scientific based ways of establishing these presumptions. However, it seems to be widely accepted for whatever reasons that the user acceptance training has been working well in the public school systems. So I guess there seems to be a no problem with people following along with that party line. Nevertheless, the courts are where we see that play out, and it's important for us to be aware of how this all does move the way our society, the way the people value some of these traditions that have been enshrined somewhat through our common law, but as we can see here, through these different case rulings and analyses, restatements, and other types of clarifications and rules, that they are being somewhat perverted and lost in the mix here. So it's up to us to be aware of and to the best we can conserve our tradition of American jurisprudence, where it's going to benefit the people, not just the ones here today, but for our posterity as well. That being said, see how many people are still here. We still got a few. We have to do our final salute here. Of course, to the public laws and the joint resolution from 54 Statute 178. And let's zoom in here a little bit here. Of course, this is authenticated from the U.S. government, GPO. So you can find this on your own. Don't take my word for it. But on May 3rd, 1940, it was the House and Senate joint resolution, public resolution number 67 here, authorizing the President of the United States of America to proclaim, "I am an American, Citizenship Day, for the recognition, observance, and commemoration of American citizenship." Notice this is not U.S. citizenship. They're saying American citizenship, which is now terminology here, as we see, because these are joint resolution here from our legislatures, whereas some 2 million young men and women in the United States each year reach the age of 21 years. And whereas it is desirable that the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. Hang on. It's desirable that the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. Impressive status. Therefore be it resolved by the Senate and House of Representatives of the United States of America in Congress assembled, that the third Sunday in May each year be and hereby is set aside as Citizenship Day, and that the President of the United States is hereby authorized and requested to issue annually a proclamation setting aside that day as a public occasion for the recognition of all who, by coming of age or naturalization, have attained the status of citizenship. And the day shall be designated as I am an American Day. Here's the observance invited. That the civil and educational authorities of states, counties, cities, and towns be, and they are hereby urged to make plans for the proper observance of this day, and for the full instruction of future citizens in their responsibilities and opportunities as citizens of the United States and of the states and localities in which they reside. So this is full instruction for all the other citizens too, right? The civil and educational authorities make plans for the proper observance of this day, right? This is observing the sovereign citizens of our nation, and the full instruction of future citizens in their responsibilities and opportunities. They have opportunities and responsibilities depending which capacity. Some might be citizens of the United States or of their individual states or their localities. Nothing herein shall be construed as changing or attempting to change the time or mode of any of the many altogether commendable observances of similar nature now being held from time to time, or periodically. But to the contrary, such practices are hereby praised and encouraged. And here's section 2, the cooperation of judiciary, etc. Either at the time of the rendition of the decree of naturalization or at other such time as the judge may fix. The judge, or someone designated by him, shall address the newly naturalized citizen upon the forms and genius of our government and the privileges and responsibilities of citizenship, it being the intent and purpose of this section to enlist the aid of the judiciary in cooperation with the civil and educational authorities and patriotic organizations in a continuous effort to dignify and emphasize the significance of citizenship, approved May 3rd, 1940. Resolved by the Senate and House of Representatives of the United States of America in Congress assembled that the life of the committee provided for by public resolution numbered 112 of the 75th Congress, creating a joint congressional committee to investigate the adequacy of use of the this is on another one here, sorry. We're getting on a chapter 184 there. This is after chapter 183, 54 Stat 178. Again, this is authenticated from the U.S. government information, GPO, if you want to look it up for yourself. But I definitely encourage everyone to be aware of this, that it is still law. It has not been repealed. And as a statute at large and joint resolution here, this is well-established law for the Republic, our self-governing Republic. Well, with that said, I'd like to thank you all for coming by, and we hope to see you all on the next one. Peace out.